That's a story, right? I don't know where you're going. You're like, sorry guys. It's really high. Did you get
All right, welcome back. Okay, please sign into the attendance. Reminder, today at 1 o'clock, so right after class, in Garrett Towns, we're having a very cool event with a bunch of federal judges coming. I'll be moderating a discussion. There'll be free lunch, so you should all come. Even if you can't stay till the end, just come, get your lunchbox quickly, sit as much as you can, and then enjoy the show. Okay? Any questions before we get started? How was the Phoenix thing? Good? Dope? Enjoy it?
Yes.
Good. All right, good. Let's get started. So we're talking about this concept of enumerated powers. And when we're talking about enumerated powers, there's a balance, right? If the federal government has a power, the states probably don't have that power. On the other hand, if the states have a power, the federal government does not have that power, right? It's usually one or the other. There's some overlapping powers, but those are not really relevant for purposes here. Why is this significant? There's been a long-standing sort of concern that you see in a lot of cases that as the powers of the central government grow, the powers of the states contract. Let's say that New York wants to ban a monopoly. Let's say that New York wants to grant a monopoly to a boating company. And Congress says, no, you can't do that. All right, then the federal law prevails. Let's say that Congress wants to ban a monopoly of sugar companies, but the states want to allow it. Who prevails there? Perhaps, yeah. What you also see is that the cases don't always line up neatly. I think the 3 cases we have today, or at least the 4 cases we have today, are examples of that. E.C. Knight, the lottery ticket case, Champion versus Ames, and Hammer versus Dagenhart, with a lot of sort of ping-pongs back and forth over the course of about 20 years. The other issue to think about is what do implied powers mean? We've read over and over again that Article 1, Section 8 lists Congress's powers, but that only gets you so far. Almost every case we'll study this semester, even if you think it's about interstate commerce, it's really not. It's an exercise of the necessary and proper clause powers. And it's a way of saying, does Congress have the implied powers, not expressed, but implied powers to enact a particular law? Judges are not always careful about saying they're using necessary and proper, but you know better. All right, any questions before we get started? So let's just walk through, and I have this, it's in your book on page, it was 30-something, 23, I'm sorry, 23 or 24. You can look along, it might be a little hard to see on the screen. But I think this is a useful chart as you're sort of making your, your outline and your notes for class to walk through our various cases. And I'll make this point very explicit. You need to know the names of cases. You may not have had that problem in other classes. They matter here. And you need to know dissents. It's true, they matter. Because very often dissents become majority opinions. Understand? Good. On exams, you don't say, that case with the sugar, or the case with the boats. No. You say E.C. Knight or Gibbons, right? I want to actually know the name. It's an open book exam. There's no excuse not to know the names, but they should be in your head anyway. If you're looking at, I said this again, if on the exam you're flipping through your notes, you are probably going to run out of time. So the notes are there, but it will not help you much. All right. So the very first case we talked about was McCulloch v. Maryland. This involved the Bank of the United States. There's no express power to charter a bank, but there's powers about regulating commerce and imposing taxes. And what Chief Justice Marshall found is that the power to charter a bank is sort of implied from these other authorities, right? Why? It's more convenient to impose taxes across the country if there are branches in every city. And it's more convenient to coin money, distribute those coins, if there are branches in every city. And it's more convenient to regulate commerce if there's branches in every state of this national bank. So this was not an express power of Congress. This was an implied power of Congress. And Marshall had this very famous line. I'm just going to paraphrase. He says, let the means be legitimate. Let the ends be legitimate. So long as there's a fit between the means and the ends, the law is valid. There's means and the ends, right? What are the means? What is Congress doing? It's chartering a bank. And what is the ends? Having a uniform economy nationwide, where commerce is regulated in each state, where federal coins are distributed, where taxes are collected, right? Are the means legitimate, Marshall says? Yes, they are. Is the end of having this national economy legitimate, Marshall says? Yeah, it is. This is a question of deference. So in other words, if Congress thinks this is a useful or conducive method of regulating our economy, it is not for the judiciary to second guess that. Everyone with me? The next case, Gibbons, was not really about implied powers, but sort of fits in this chart anyway. It's about the scope of commerce. What does commerce mean? And Chief Justice Marshall defines commerce as intercourse. And say, oh, dirty word, right? No, it means things moving from one state to the other, involving navigation, right? A boat moving from New York to New Jersey was commerce. But Marshall says also that commerce is not limited to only stuff between the states. It could also involve stuff going into a state. For example, if a boat goes from New Jersey to New York, up the Hudson River into New York State. But Marshall still makes clear commerce that's entirely within one state is beyond the scope of federal power. You can't have commerce entirely in one state under the Commerce Clause. But what you're already starting to see is Marshall's going a little bit beyond just the Commerce Clause. He doesn't say it, and it's not there. You won't see it written anywhere. But he sort of hints that there might be some laws that are necessary for Congress to reach inside the states. And we hear this word necessary. What do you think? Necessary and proper. And if those ends are legitimate, those means are legitimate, then Congress can go inside the state. But then we jump ahead a couple decades to the Tawney Court in Poultry, Pennsylvania. And most people study this case because it involves slavery. And of course, it's a very important case concerning slavery, but its real sort of significance at the time was about the scope of federal power. You had the southern states saying, we want this broad federal power to support the fugitive slave law. And yet Pennsylvania, a northern state, an abolition state, a free state, saying, no. Federal power is limited. The states can police kidnapping within our borders. Congress has no power to do this. And you have Chief Justice Chase early in his life saying, no. There's no power for Congress to enact this law. It's merely governing the relationship between the states. So you have a decision in which Justice Story, a Federalist from Massachusetts, a James Madison appointee, agrees with Roger Tawney, a slaveholder from Maryland. And they agree that Congress has this broad implied power And even if there's no express power to regulate slaves in the Constitution, Article 1, Section 8, it relates to the broader scope of federal authority over the nation. There's not much limit if you read Justice Story's opinion. In fact, I just wanted to show you this. You read a couple cases today. You read E.C. Knight, you read Hammer. Just look how far out Prigg goes, and look at the cases from the 1900s. None of those cases go quite as far as Prigg, and that's significant. Prigg, and I'll get to the Knox case in a few moments, Prigg basically sees no limitations on this sort of federal power. All right? Everyone with me? Yes, sir. Brian?
Like no limitation means like you say that the necessary proper clause has no limitation.
If you believe that Congress has this broad power to sort of regulate the national economy, and Congress can enact any law that is useful to regulate this broad national economy, then there are no limits. I mean, I'll get to that in a few minutes with E.C. Knight and Champion versus Ames and Hammer. But in Justice Story's decision in Prigg, if you read that carefully, there really is no limit. It's basically envisioning whatever can pass political muster, that is, whatever members of Congress support, that will be the scope of federal power. Yes, Stephen?
In Prigg, isn't there like a small little limit that has to relate to like the federal, any federal law or anything?
Yeah, that's pretty broad though, isn't it?
Yeah.
In other words, the federal government has an interest in a lot of things. And if it relates to anything that's a federal government interest in, that's enough. You don't really see language in Prigg that's sort of like, there's some big limit. It's kind of like, well, there might be a limit. We don't have to talk about it. Now, Congress wouldn't actually do all the things that Prigg talked about, right? But they at least open the door to it. But again, if you read Prigg, it's about McCulloch v. Maryland. Let the ends be legitimate. Let the means be legitimate. So long as it's plainly related, that's enough. All right, then we jump forward another 2 decades or so. And again, you're all, what, in your mid-20s, 30s maybe? This is going over the course of decades upon decades. This doesn't happen overnight. We're reading it now as if, this one thing happened after another, right? But these are happening. Look, McCulloch was 1819. Prigg was 1842. That's 23 years. And then you got DeWitt in 1869. So almost 50 years. None of you are that old, I don't think, between McCulloch and DeWitt, right? So there's a lot of time developing. I don't want to compress this too much, but it's called a brief history, so I will compress a little bit. So then we get to the Chase Court. This case called DeWitt, which is not studied widely. Most people never even heard of it. DeWitt was about the sale of oil within a state, and Congress had to ban the sale of petroleum oils within the state. And the government said, we need to ban the sale of this kind of oil because we want to encourage taxation for other types of oil. The court says, no go. That's too remote. The relationship between the means and the ends isn't tight enough. In other words, okay, I get it. The ends is you want to raise money. Okay, that's legitimate, right? And the means is you're trying to ban the sale of oil, right? But there's a very big gap between banning oil A and collecting taxes on oil B, right? There's not a close relationship. Is that consistent with McCulloch? Is that consistent with Justice Story and Prigg? Maybe, maybe not. I think DeWitt is closer to McCulloch. You can see how we sort of represented it here, up there. McCulloch's over there, and DeWitt's over here. So I think what Chase did in DeWitt is sort of bring it back to where things were in McCulloch. I think DeWitt is faithful to McCulloch, and I think Prigg goes too far. But that's just my read. But maybe you might disagree. Everyone with me so far? And then shortly after we get DeWitt, we get to Hepburn, right? And this is a case of much significance. No, I mean, really, does anyone care about the oil case? That was not a big deal, right? That this one poor dude, I think it was in Michigan, prosecuted for selling oil. No one cares. Hepburn, though, BFD, right? Really big deal. Hepburn concerned paper money and legal tender. Right? Could you force people to accept paper money, greenbacks, to satisfy some debt? This case was a 5-3 decision. Actually, it was 4-3 by the time it was decided. So there was not even a single, 5-member majority. And what Chief Justice Chase said is that no, the paper money law was not valid. That Congress had lots of authority, but there was no authority that specifically authorized paper money. And this cannot be viewed as an implied power. In other words, the sort of the end of having a national economy perhaps was legitimate, but the mandate to make people take this money was too far attenuated, too far separated. There wasn't enough of a fit between the means and the ends. Is this decision consistent with McCulloch? It's harder to say, in my opinion. I think in this one, Chase was pushing a little bit further against McCulloch, but we sort of kept it at the same level because you can't actually overrule McCulloch. That would be a no-no. At that point, it was a 50-year-old decision. It was sort of deeply rooted in our traditions. But then, about a year later, things sort of changed, right? 2 new members of the court were appointed by President Grant. And what was a 4-3 decision went one way, went 5-4 the other way. And in Knox against Lee, the court upholds paper money. So in one sense, Knox is narrow, right? How is Knox narrow? Knox says, well, we're in an emergency, right? And in times of emergency, government has to have more authority. I mean, that's certainly something people say a lot. It's certainly a common refrain. Although later the court would say, well, even though the emergency is over, there's still paper money. I mean, if you look at your wallets, you still have it, right? The Civil War's been over for a long time. We didn't get rid of paper money after the Civil War. But at another level, the court had some extremely broad language, saying that basically the federal government can do whatever they want. Under McCulloch, there's not really a limit. That is for the political branches to decide. And just we sort of see how we graph this out. Again, this is me and Randy, but I think we're right. Knox is probably one of the furthest statements of federal power ever. It went, I think, in our view, beyond whatever they did in the New Deal. I think there's a lot of sort of emotion in this case. I think there was a lot of anger that in the time of war, the Supreme Court came in and said no paper money. And you have these 2 new members like, all right, we're in the court. Let's overrule a 1-year-old precedent. Yeah, let's just get rid of it. And I think there was a lot of passion. I think you saw this in Chase's dissent as well. But this is sort of this broad sweep of all the precedents from the first 90 years of the Republic. Okay, questions so far? It's all review, nothing new. All right. So let's start with our cases for today and talk about the progressive era. So what is the progressive era? Did anyone ever study the progressive era in school? Anyone? Yeah, Brian?
It's the beginning of like populist movement following like the Gilded Age. It's a lot of movements in like labor, progressive movements, right to vote.
Yeah, anyone else? Yeah.
It's like marked by like a big like shift against like corporations and like large like conglomerates that just kind of do what they wanted instead of operating like super well paid powerful.
Okay. Anyone else want anything? Yeah, in the back, Treya.
It was just a time where there was like rapid industrialization, like making urban areas.
Okay. Yeah, good. I think all of you sort of said the right things. So the United States has different periods of time. And just one thing I'd love to study is how what's going on in the world relates to what's going on in the Supreme Court. You can't separate the two. And for example, the Marshall Court was the early court, like this new republic was just getting started, figuring out how do we have a bank and how do you have boats and stuff like that. And the Taney Court was basically defined by the issue of slavery leading up to the Civil War. Prigg was sort of a leading case. Chase Court was decided in the period known as Reconstruction. That was the period after the Civil War. Why was it called Reconstruction? Literally, the United States was reconstructing, was rebuilding itself after the Civil War tore it asunder, right? Okay, we need paper money, right? We need to have these civil rights laws. We'll do this later this semester. This is all an effort to try to rebuild the country after the Civil War. But by the time you get to the 1880s, right? The Civil War finished 1865, depending how you want to count it. Reconstruction lasted 10 or 15 years. And by the time you get to the 1880s, Reconstruction is more or less over, right? That's not to say that the goal of Reconstruction was satisfied. It certainly wasn't. In many regards, Reconstruction didn't work. But the idea that you need to reconstruct the South was sort of just moved past it. You know, amnesty was granted to former Confederates. Southern Democrats were elected back to Congress. Jim Crow began. The enterprise of Reconstruction ended in the late 1800s. But around the same time, the so-called progressive era began, and it's hard to sort of pin down a specific year or even theme. But the progressive era was marked by a few different trends, one of which I think Shrey mentioned was industrialization. Industry was building, factories were developing, transportation was increasing, more people living in sort of urban, crowded cities than had been before. These weren't like people living on these bucolic pastoral farms. There was also a sense that government should be used to constrain business, or at least that was the view in some quarters. And states began experimenting with a number of laws involving labor, for example, imposing minimum wage laws, maximum hour laws, workplace safety laws, food safety laws, the jungle, Upton Sinclair, maybe you read about this at some point in your studies, right? All these sorts of state laws are being enacted to try to limit what limit what private businesses could do, and perhaps try to increase the condition of workers. There also were efforts to increase voting. So there was the suffrage movement to get women the right to vote, the temperance movement to ban alcohol, prohibition, right? All these sorts of things were swirling in the late 1800s and early 1900s. Around the same time, it wasn't just the states that were trying to enact these laws. It was also Congress, the federal government. Theodore Roosevelt, the great Bull Moose Party, right? He was one of the first major progressives who was president, who tried to use the power of the government to restrain monopolies and to increase food safety, the Food and Drug Act. So there were lots of these laws passed in this time. But what's sort of curious is the Supreme Court, where even as perhaps the populace was moving, and I'll say the left, that's kind of a crude characterization, but it's moving towards progressive, right? What they might call progress. The court was still kind of more old school, traditional, conservative, and not the same way that you might think today, but they favored the laws that were there when they were kids. It's when you get older, you'll see this. People like things like when they were young. That's just how things work. People don't like to change. It's just part of who we are. So the court was seen as somewhat of a impediment to this progressive movement. And we see this in the three of the cases for today: E.C. Knight, Champion versus Ames, and Hammer against Dagenhart. These were three cases where during the progressive era, the span of about 23 years, the courts went back and forth. And don't pretend these are the only cases. There were a lot of cases during this time. I'm going to give you kind of like a snippet, give you the high water marks, the high points. All right, I've been talking for way too long. Way too long. Who's next? How long have you been waiting for the entire class? You've been dreading all day being called on? Good. Oh, that's a good answer. It's been a long weekend. All right, Shrey, so you want to give me the facts, please, in E.C. Knight?
So there were 4 companies that were engaging in the manufacture of sale of sugar, and the American Sugar Refining Company, through the sale of stock, obtained the control of all of these sugar refineries, and that violated the Sherman Antitrust Act.
Very good.
Which basically said that an attempt to monopolize or to monopolize any sort of trade and commerce.
Let me just stop you. Trade in commerce. Why is that significant? Trade in commerce. What's the statute actually regulating? Is it regulating commerce?
Yeah.
Is it only regulating commerce? You just said a different word.
No, it's regulating trade and commerce.
Trade. What? Is there a difference between trade and commerce? What's a trade?
It is like the act of moving things.
Is that all trade can mean? What if you learn a trade? Whatever, learn a trade? You learn a trade, you're learning a skill. You have to build something or to make something? Carpentry, I don't know. Plumbing? Manufacturing, is that a trade? So, Shreya, is this statute broader than just regulating commerce? Yeah. Does the Constitution have a trade clause? There's a commerce clause, right? So what clause is really doing the work here? Just the second one. It's not the commerce clause, right? Commerce clause for sure, right? It's necessary and proper. So just when you read these statutes, there's like a tell. Right? What do I mean by a tell? What I mean is the statute itself says we are going beyond just regulating commerce, regulating other stuff too, which means you must have necessary and proper. Okay? So let's try a question. Oh man, 10 of you absent. That's a lot. If you haven't signed in, please do. All right, so question number 1, please. Let's do this question. Okay, according to the court, question number 1, according to the majority in EC Knight, which comes first, commerce or manufacture?